Hi, I'm Ed Alexander with the Entrepreneurship Law Firm, and this is the Business Killing Mistakes blog. Today we're going to talk about securities laws. I am a big fan of Craigslist. Love going on there and seeing all the junk that people have for sale and seeing if you can get a deal here or there. My particular favorite are kayaks, because I love going out kayaking. But occasionally I'll go to the business section and kind of scroll what's over there in the business area. And it's always shocking to me that you get somebody who put up an ad saying, hey, I need $50,000 for my business as a silent partner. This is a clear violation of the securities laws. And so I thought I'd talk a little bit today about what the securities laws are. Anytime that a person offers a security for a business, they have to comply with the securities laws. Okay, so let's figure out what is a security for a business. The traditional definition of a security is it's something where I'm going to give the business owner money and expect a return of my money at a higher rate without any effort on my part. And there have been cases all over the board, even cases as interesting as buying orange trees in an orange grove, that constitute securities. So the traditional security that we all think of is stock, people buying stock. But it also includes profit participation contracts and actually promissory notes if they're convertible or if they're sold to a non-institutional investor. So it's important to know that any time that you're raising capital, you have the situation where the securities law applies. Now, one of the key things to remember, though, is that if people are joint venturers with you, so that you're putting in money, but they're going to have control or a part of the control of the business, that may or may not be a security. Okay, so now we know what a security is. Let's move on to talking about when the securities laws apply. The general rule when it comes to securities laws is that any time a security is sold, it needs to be registered. And registration is going through the process of filing various documents with the Securities and Exchange Commission or the various state securities regulators. And so that's a very costly, expensive, time-consuming process. So business owners usually don't want to go that way. Well, the securities laws provide for an exemption, or actually more exemptions, for the registration process. And what you've got to do is, if you don't want to register, you've got to look at those exemptions. And most often, the one that smaller entrepreneurs, startup entrepreneurs, typically use, whether they're looking for angel funding or they're looking for general outside investors, is an offering of $1 million and less. And this would be a Rule 504 or Regulation D type offering. And in the state of Florida, the blue sky provision, the Florida state law that's applicable to this, would be 517.061 paren 11. I know it sounds long. But essentially, you've got to comply. You've got to check the list off out of these statutes. And as long as you do those things, then your offering will be exempt from registration. But if you don't do that, then the downside is that the people that you sell securities to can show up later on and say, hey, wait a second, I want my money back. And guess when they're going to show up and want their money back? Of course, it's not when the business is successful. It's only if the business fails. And in that case, if you were involved in the sale of the security, you might have personal liability for the money to give back to them. So following the securities laws is critical. If you need more information on this topic or any other business topic, please feel free to go to my website, www.entrepreneurshiplawfirm.com, or give us a call at 407-649-7777. Thanks, and I look forward to seeing you next time.